Hey everybody, welcome back to the channel today. We've got a little something different for you. We are on site here at the Federal District Court in the Southern District. This is where Judge Benitez just held a hearing where he heard motions on 4 different cases. That would be CRPA's Duncan case, CRPA's Rhodey case, and then the Miller case, and then also a Faust case. So we have here some people who you might not see every day, but I wanted to bring to light that these are the people who are fighting for your Second Amendment rights on a daily basis. I want to go ahead and introduce ourselves here. Obviously, somebody who's been on the channel a lot, CRPA volunteer president Chuck Michelle. Chuck, thank you for being with us.
My pleasure, as usual. Today was a great hearing. I want to introduce my team. They did a great job in there today on the 2 CRPA cases, Duncan challenging the large capacity magazine ban and Rhodey challenging the ammunition background check. There were also 2 other cases in there that we've been watching, keeping a close eye on and working with their lawyers. That's the Miller case, challenging the black rifle ban, basically the quote unquote assault weapon ban in California, and the Faust case challenging the prohibition on possessing billies. So it's not just firearms, it's ammunition and other types of arms too. So my team today, Anna Bevere was the lead counsel on the Duncan matter, arguing against the large capacity magazines. Sean Brady was lead on the Rhodey case. Costas Moros was the lead on, or the backup on, both of those cases. And we did a great job today. So kind of want to just summarize what Judge Benitez did today. Remember, this was not a trial. This was not a hearing on the merits of our arguments. This was a status conference. And it was a very unusual status conference because he had 4 cases called at the same time. Usually it's 1 case at a time. He had 4 cases, so all the lawyers for the DOJ and all the lawyers on all these different cases were all able to comment as the hearing went on. But I think we did not get any definitive rulings about a win or a loss, but we definitely got some guidance on where he's coming from. If you remember, the big argument that we're having now is about how much expert historian testimony should be allowed to flesh out the history and tradition of the times, and whether or not laws that existed at the passage of the Second Amendment or the passage of the 14th Amendment are analogous to the current laws, so that these current laws would not be unconstitutional. Remember, that's the Bruin test. If the laws are not consistent with what was acceptable back at the passage of the Second Amendment or the 14th, then these laws today are not constitutional. We're arguing, and I think we're absolutely right, and it looks like Judge Benitez gets it, that a ban on magazines that hold over 10 rounds, there's nothing in history that's analogous to that, and nor is there anything analogous to background checks to buy ammunition, especially because California's system of checking those backgrounds when you buy ammunition is so screwed up, and I'll let Sean talk about that a little more. But so let's go down the line and let Anna tell her impressions of what came on Duncan, and Sean on.
I was curious to get your guys' initial, reactions to what happened in there. To the layman, and I mean, we can call this 4 attorneys and a guy who does CRPA videos, but it really seemed like Judge Benitez wanted to get this going as quickly as possible. Can you tell me why that is? I'm just curious. Obviously, he's heard a couple of these cases for years now, and there were plenty of motions to extend this, extend that. Can you touch on that, why that's happening in your opinion on the state side, and why it is Judge Benitez wants to hurry this along?
I think I'll take that question. Thank you for it. What I think we've seen, I mean, Duncan was filed back in 2017, and Judge Benitez would like to see these cases to a final conclusion, at least in the district court, because we know that it's going to go up on appeal, but he wants to see it. He wants to see the case handled and done out of his courtroom as soon as possible, because we're talking about fundamental rights. And whenever we're talking about fundamental rights, it's extraordinarily important to not only the plaintiffs who have brought the case, but to every single Californian who is trying to vindicate their right through the lawsuit. It's also important to the state, right, to figure out, to know once and for all whether or not the laws that it's passed are appropriate and constitutional. So that's why Judge Benitez wants to see this case handled, all 4 of the cases handled quickly. The reason you see the state constantly asking for some more time. We need more months for discovery. We need time to depose their experts. They're really just trying to buy some more time to continue to fill the record with what we think is completely irrelevant historical context, attitudes about why there were no laws that are relevant to the case. So they're just trying to buy more time because they know that it's inevitable that Judge Benitez is going to find all 4 of these laws unconstitutional.
Well, and I found that pretty interesting. I recently did a video on a judge from, I think it was Mississippi, who was kind of criticizing the Bruen decision, talking about how much time and effort it's going to take to bring in historians. Yet we found out, or at least I found out in there, that some of the people who have already gone on record have been doing, this research into Second Amendment history and tradition for 2 decades. So that's obviously something that we know. I think the ultimate reason for Judge, at least from what I took, the ultimate reason that he wanted to have all of these 4 cases at the same time was because he thought it was a good idea to do the text, history, and tradition together for all of them. But Shauna, I saw you when you were up there make sort of a distinction for Rhodey. Can you tell me about that?
Sure, and I think you have it right. Judge Benitez wants this thing moving along, and like Anna said, for several reasons, but also I think in part because he's dedicated so much of his time, and he's obviously done a lot of work. Based on what he said today, I see him reading this stuff in his bed at night. So he's dedicated a lot of time and his own personal resources to addressing this issue. And so I think he's a little frustrated with the ping-ponging back and forth between the Ninth Circuit and then SCOTUS, and the landscape, the battlefield keeps changing. And so I think he's just trying to do his part in just setting things straight and saying, let's just get down to the brass tacks and get this thing done. The distinction between Rhodey that I was making and these other cases is Rhodey is more of like a manner type restriction, right? They're not banning ammunition. They're requiring you to jump through certain hoops, whereas they're banning magazines, they're banning billies, they're banning the so-called assault weapons, right? And the background check piece of California's law with respect to ammunition has some roots, arguably, right? The state's going to argue that, well, the Bruen decision found background checks or mentioned the background checks for concealed carry permit holders is going to probably pass muster. It's going to be okay. And so the state's going to try to parlay that into well, that means background checks for anything related to firearms is going to be constitutional. And our pushback is, no, ammunition is distinct. It's obviously different in kind than, say, buying a firearm, which you do once in your life sometimes. Obviously, don't get me wrong. I know people buy them like all the time, multiple times. But, buying a firearm once or twice, maybe in a year, is wholly different than going under a background check every single time you buy ammo, right? So our argument is going to be ammunition background checks are different. But even if the court were to accept that background checks on ammunition are acceptable under the Constitution, just like they are for concealed weapon permits, that this particular background check that the state of California has implemented is so burdensome and so unreasonable that even if background checks generally are going to be okay, this particular one would fail on its own facts. And I raised that because I wanted to ask the court if we needed to do additional discovery on that. And much to our pleasant surprise, Judge Benitez indicated that he had already found in our favor on that in the previous iterations in our preliminary injunction motion that went up to the Ninth Circuit and has been remanded. And so he's basically sticking with that. And all he's focused on at this point is addressing what he has to do post-Bruen and whether Bruen changes the victories that he has already given us in both the Duncan case and the Rhodey case. So we are sitting pretty at this point.
Well, yeah, and I think we're sitting pretty on both the Rhodey case and the Duncan case, both cases that Judge Benitez has already ruled on in our favor. He showed a little bit of question, a little reservations as to why this was passed down to him in the first place, which I thought was interesting. I guess going out to 30,000 feet from today, what is the silver lining here? We have people who have been following these cases since 2016, 2017. Obviously, there's a sentiment from Judge Benitez here that he wants to get this ball rolling quickly. What do we take away from these hearings, and what is our silver lining?
I
Well, it's a couple of things. First of all, as frustrating as it might be to people that Freedom Week did not, in fact, start again today, there is a light now at the end of the tunnel. It's about 70 days, I think, if I did my math right, from the supplemental when all the briefing is done. At that point, he will take it under submission and make a ruling. But the bigger win today is that, as Chuck was talking about, the state really wanted to stuff the record with expert testimony to make their biased experts the equivalent of laws actually passed in the 19th century. And that was soundly rejected today. That is not going to happen. And also, he capped the time limit the state can use. They can't look at 20th century laws anymore. Well, he said they can submit something, but the implication was he was not going to take that very seriously. So I think those are the two major wins today. There is a light at the end of the tunnel, everyone.
Light at the end of the tunnel, indeed. I want to thank all of you guys for being with us here today. If you like seeing these videos with people a lot smarter than me, please go ahead and like, share, and subscribe to this channel. It really helps us with the algorithms and getting this information out to everybody that we can. Thank you all again for being here, and we'll see you guys on the next one.